Welcome to California Indian Legal Services webinar on advocating for and educating tribal foster youth. This webinar is intended to be used as a resource tool for ICWA advocates appearing in state court proceedings. It is not intended to be a comprehensive discussion of all legal authority and factual scenarios. Further research and/or consultation with an attorney may be required. Education is vital for all youth, especially foster youth, yet it is an area that's often overlooked within the dependency process. It is well recognized in California that children in the system are disproportionately represented as to disabilities and face systemic challenges to attaining self-sufficiency. Each year, more than 20% of California's teenagers drop out of high school. 30% of California's elementary school pupils experience school adjustment problems, many of which are evident the first 4 years of school, that is, kindergarten and grades 1 to 3. Problems that face our children experience, whether in school or at home, that remain undetected and untreated, grow and manifest themselves in all areas of their later lives. There is a clear relationship between early adjustment problems and later adolescent problems, including, but not limited to, poor school attendance, low achievement, delinquency, drug abuse, and high school dropout rates. In many cases, signs of these problems can be detected in the early grades. The California legislature has said it is in California's best interest, both in economic and human terms, to identify and treat the child difficulties that our children are experiencing before these difficulties become major barriers to later success. It is far more humane and cost-effective to make a small investment in early mental health intervention and prevention services now and avoid later costs, including but not limited to foster care, group home placement, intensive special education services, mental health treatment, or probation supervised care. Accordingly, the child's best interest and welfare is the linchpin of the dependency process. There is a clear duty of the dependency courts and those persons within it to serve and protect the child subject to the dependency action. The juvenile court has the authority to supervise and maintain the child or youth's educational stability. The court, in particular, must continually inquire about the educational and developmental services needs of the youth, and to the extent to which they are being addressed. Educational issues must be addressed throughout the life of the whole dependency case. This starts off at the initial or the detention hearing. So to the extent that the information is available, at the initial or detention hearing, the court must consider 1. Who holds educational and developmental service decision-making rights, and identify the rights holder or holders, and 2. Whether the child is enrolled in and is attending the youth school of origin. If the child is no longer attending the school of origin, or if the youth is at risk of removal from that school, the court must find whether or not certain procedural protections were followed according to rules set forth in the California Rules of Court. The court must also determine whether the child's out-of-home placement is the environment best suited to meet the exceptional needs of a child with disabilities and promotes educational stability through proximity to the child's school of origin. At the dispositional hearing, and at all subsequent hearings, the court must 1. Consider and determine whether the child's educational, physical, mental health, and developmental needs, including any need for special education and related services, are being met. 2. Identify the educational rights holder. And 3. Direct the rights holder to take all appropriate steps to ensure that the child's educational and developmental needs are being met. The court's required inquiries will be reflected in the court's orders. The court's findings and orders must address each of the following. 1. Whether the youth's educational, physical, mental health, and developmental services needs are being met. 2. What services, assessments, or evaluations, including those for developmental services or for special education and related services, the youth may need. 3. Who must take the necessary steps for the youth to receive any necessary assessments, evaluations, or services? And 4. Whether the educational or developmental services decision-making rights should be limited or, if previously limited, whether those rights should be restored. Additional orders are needed if the youth's educational placement changed during the period under the review. The court must also then find whether the youth's educational records, including any evaluations for a disability, were transferred to the new educational placement within 2 business days of the request for enrollment in the new educational placement, and 2, whether the youth is enrolled in and attending school. To assist the court in making this determination, the agency reports must, to the extent the information is available, must address the following. 1. The child's age, behavior, educational level, and developmental status, and any discrepancies between his or her age and his or her level of achievement and education or level of cognitive, physical, and emotional development. The child's educational, physical, mental health, or developmental needs. The child's participation in developmentally appropriate extracurricular and social activities. Whether the child is attending a comprehensive, regular, public, or private school. The child's physical, mental, or learning-related disabilities or other characteristics indicating a need for developmental services or special education and related services. Where the child is under 3 years of age, the agency social worker report must also address whether the child may be eligible for or is already receiving early intervention services or services under the California Early Intervention Service Act, and, if the child is already receiving services, the specific nature of those services. Where the child is between ages 3 and 5 and is or may be eligible for special education and related services, the agency social worker report must also address whether the child is receiving the early educational opportunities provided by Education Code 56001, and, if so, the specific nature of those opportunities. The agency social worker report must also include whether the child is receiving special education and related services or any other services through a current IEP, a 504 plan, or is or may be eligible for developmental services, and if so, the specific nature of any of those services with a copy attached to the report. The recommendations and case plan goals must also be provided to meet the child's identified needs. The agency social worker report must also address whether the parent's or guardian's educational or developmental services decision-making rights have been or should be limited or restored, and the reasons why. And lastly, should identify the educational rights holder. At any time after the dependency petition is filed and until the petition is dismissed, the court can temporarily limit the right of the parent or guardian to make educational or developmental services decisions for the child and temporarily appoint a responsible adult to make educational or developmental services decision for the child. However, for the court to make this order, it must find that each of the following conditions exist. 1. That the parent or guardian is unavailable, unwilling, or unable to exercise educational or developmental service rights for the child. 2. That the county policing agency has made diligent efforts to locate and secure the participation of the parent or guardian in educational or developmental service decision making. And 3. That the youth educational and developmental services needs cannot be met without a temporary appointment of a responsible adult. In all cases in which a minor is adjudged a dependent of the court may make any and all reasonable orders for the care, supervision, custody, conduct, maintenance, and support of the child. The mechanism for doing so is through the court-ordered case plan. The case plan should address not just the parent's needs, but also that of the child. Among other purposes, the child's case plan is designed to 1. Ensure that the child receives protection and safe and proper care and case management. 2. Address the child's needs while in foster care. And 3. Ensure the educational stability of the child while in foster care. The case plan must be updated as the service needs of the child and family dictate. At minimum, the case plan must be updated in conjunction with each status review, but no less than every 6 months. The agency must consult with the Indian child's tribe in the development of the case plan and plan for permanent placement. If the court finds that the agency did not consult with the child's tribe, the court must order the agency to do so, unless the court finds that the tribe is unable, unavailable, or unwilling to participate. So where do the child's educational rights and protections come from? Let's take a look at some of the sources. First, let's look at the duties under federal law. Congress has specifically stated that it is its policy that each state educational agency shall ensure that each child of a homeless individual and each, quote, homeless youth has equal access to the same free, appropriate public education, including a public preschool education as provided to other children and youths. Homelessness alone is not sufficient reason to separate students from the mainstream school environment. Homeless children and youths should have the same access to the education and services needed to ensure that the youth can meet the same state student academic achievement standards to which all students are held. So what is the federal law? It is the McKinney-Vento Homeless Assistance Act. This is the federal legislation that ensures the educational rights and protections of children and youths experiencing homelessness. So let's look at the definition for homeless children and youths. Homeless, homeless individual, and homeless person includes, but is not limited to, an individual or family who lacks a fixed, regular, and adequate nighttime residence, and also children and youths who are sharing the housing of another person due to loss of housing, economic hardship, or similar reason, are living in a motel, hotel, trailer park, or camping grounds due to the lack of alternative adequate accommodations, are living in emergency or transitional shelters, are abandoned in hospitals, or are awaiting foster care placement. What are the rights and protections under that federal law? The sections include, but are not limited to, school of origin, immediate enrollment, records, comparable services, including transportation, vocational and technical education, collaboration and coordination, and educational liaison. Now let's shift to the duty under state law. That would be the California Education Code. In it states that it is the intent of the state legislature to ensure that all students in foster care and those who are homeless have a meaningful opportunity to meet the challenging state student academic achievement standards to which all students are held. It is the express policy of the state legislature that in fulfilling their responsibilities to these students, educators, county placing agencies, care providers, advocates, and the juvenile courts must work together to maintain stable school placements and to ensure that each student is placed in the least restrictive educational programs and has access to academic resources, services, and extracurricular and enrichment activities that are available to all students, including but not necessarily limited to interscholastic sports. In all instances, educational and school placement decisions shall be based on the best interest of the child and shall consider, among other factors, educational stability and the opportunity to be educated in the least restrictive educational setting necessary to achieve academic progress. The rights and protections under that state law is similar to that of federal law. The sections include, but are not limited to, school of origin, immediate enrollment, records, collaboration and coordination, and an educational liaison. When considering these educational protections and rights, it is important to note that these sections are not intended to supersede or exceed other laws, including those governing special education services, juvenile court placement, expulsion, and other various areas. Please review the sections on these slides. So let's now turn to the child's rights in education. The child's right to school of origin. At the point of any change or any subsequent change in residence, once a child becomes a homeless child, which, you might recall, includes those children awaiting foster care placement, the local educational agency serving the child must allow the child to continue his or her education in the school of origin through the duration of homelessness. What happens if the child's status changes before the end of the academic school year so that he or she is no longer, quote, homeless? Either of the following would then apply. 1. If the child is in high school, then the local educational agency shall allow the formerly homeless child to continue his or her education in the school of origin through graduation. Or 2, if the child is in kindergarten or any of the grades 1 through 8, the local educational agency shall allow the formerly homeless child to continue his or her education in the school of origin through the duration of the academic school year. To ensure that the homeless child has the benefit of matriculating with his or her peers in accordance with the established feeder patterns of school districts, the following to apply. 1. If the homeless child is transitioning between school grade levels, the local educational agency shall allow the homeless child to continue in the school district of origin in the same attendance area. 2. If the homeless child is transitioning to a middle school or high school, and the school designated for matriculation is in another school district, the local educational agency shall allow the homeless child to continue to the school designated for matriculation in that school district. How is school of origin defined? The school of origin is the school that the homeless child attended when permanently housed or the school in which the homeless child was last enrolled. How is school of origin defined when there are several schools that the child attended? If the school the homeless child attended when permanently housed is different from the school in which the child was last enrolled, or if there is some other school that the child attended with which the child is connected and that the child attended within the immediately preceding 15 months, then the educational liaison, in consultation with and with the agreement of the child and the person holding the right to make educational decisions for the child, must determine in the child's best interest the school that is to be deemed the quote, school of origin. As soon as there is a risk that the foster child may be transferred from his or her current school, the county placing agency or the county office of education shall contact the local educational agency of the student. The county placing agency shall notify the local educational agency of the date that the student will be leaving the school and request that the student be transferred out. As part of that notification, the placing agency shall provide any available information on immediate past educational placements to facilitate prompt transfer of records and appropriate educational placement. If, prior to removal, the child had a disability and an active individualized education program, the agency must send notice of the impending change of placement to the local educational agency that provided a special education program for the child. The notice must be sent in writing and at least 10 days before the removal. Within 1 court day after making the placement decision, the agency must send notice of the proposed placement decision to the child's attorney and the child's educational rights holder or surrogate parent. Then, after receipt of the notice, the youth's attorney must, as appropriate, discuss the proposed placement change and its effect on the youth's right to attend the school of origin with the child and the education rights holder. The youth's attorney and/or the education rights holder may request a hearing on this issue. The court may set the hearing on its own motion. The youth must be allowed to remain in the school of origin pending this hearing and pending the resolution of any disagreement. The educational liaison may recommend that in the child's best interest, the child's right to attend the school of origin be waived. The recommendation would be after consultation with and the agreement of the foster child and the educational rights holder. The child would then be enrolled in a public school that students living in the attendance area in which the foster child resides are also eligible to attend. Before making a recommendation to move a foster child from his or her school of origin, the educational liaison shall provide the foster child and the person holding the right to make educational decisions for the foster child with a written explanation stating the basis for the recommendation and how the recommendation serves the foster youth's best interests. What then happens if the child remains at their school of origin? One issue would be that of transportation. Under federal law, if the child remains in his or her school of origin and transportation between his or her foster care placement and the school is not otherwise available, the placing agency must then provide the child's caregiver with reimbursement for the reasonable costs of transporting the child to and from school. That requirement is under federal law, but the California Education Code similarly makes clear that the local educational agency and the county placing agency are encouraged to collaborate to ensure maximum use of available federal monies, explore public-private partnerships, and access any other funding sources to promote the well-being of foster children through educational stability. What then happens if the child changes schools? There is a right to immediate enrollment. This right exists even if there are outstanding fees, fines, textbooks, or other items or money due to a school, or if he or she does not have the clothing or records normally required for enrollment, including, but not limited to, academic records, medical records, proof of immunization history, proof of residency, or even school uniforms. The educational liaisons from each school, that being the new and former school, must also each ensure that the student's records are provided to the new school within 2 days of the request for enrollment. Lastly, a foster child who changes residences pursuant to a court order or decision of a child welfare worker or a homeless child or youth shall be immediately deemed to meet all residency requirements for participation in interscholastic sports or other extracurricular activities. What sources, then, are available to an ICWA advocate to assist in advocating for the youth? First would be the educational liaison. Each local educational agency must designate a staff person as the educational liaison for foster children. It is important to remember that the educational liaison is not granted any authority that supersedes that of the education rights holder. The role of the educational liaison is advisory with respect to placement decisions and determination of the school of origin. The educational liaison must do both of the following. 1. Ensure and facilitate the proper educational placement, enrollment in school, and checkout from school of foster children. And 2. Assist foster children when transferring from one school to another school or from one school district to another school district in ensuring proper transfer of credits, records, and grades. The educational liaison also may have a role in the expulsion process, where designated by the superintendent of the local educational agency. The educational liaison may be obligated to notify a foster child's attorney and the appropriate representative of the county child welfare agency of any pending expulsion and/or suspension proceedings. The educational rights holder is responsible for investigating the child's educational and developmental service needs, determining whether those needs are being met, and acting on behalf of the child in all matters relating to the child's educational or developmental services. The educational rights holder must ensure the stability of the child's school placement. At any hearing following a change of educational placement, the educational rights holder must submit a statement to the court indicating whether the proposed change is in the child's best interest and whether any efforts have been made to keep him or her in the school of origin. The educational rights holder must also ensure that the placement is in the least restrictive educational program appropriate to the child's individual needs. The education rights holder must also ensure that the child has access to the academic resources, services, and extracurricular and enrichment activities. The education rights holder must also ensure that the child has access to any educational and developmental services and supports needed to meet the state standards for academic achievement and functional performance, or, with respect to developmental services, to promote community integration, an independent, productive, and normal life, and a stable and healthy environment. The education rights holder must also ensure that the child receives prompt and appropriate resolution of school disciplinary matters. The education rights holder must also ensure that the child receives the provision of any other elements of a free, appropriate public education. The education rights holder must ensure that the child has access to the provision of any appropriate early intervention or developmental service otherwise required by the law. And lastly, the education rights holder must ensure that the child has access to the records for and to present evidence in a truancy proceeding. The educational rights holder's responsibilities include that, before each review hearing, the educational rights holder must do one or more of the following. 1. Provide information and recommendations concerning the child's needs to the assigned social worker or probation officer. 2. Make written recommendations to the court concerning those needs. And 3. attend the review hearing, and participate in any part of the hearing that concerns the child's education or developmental services. This means that the educational rights holder must meet with the child at least once and as often as necessary to make decisions that are in the best interest of the child, be culturally sensitive to the child, comply with all federal and state confidentiality laws, participate in and make decisions regarding all matters affecting the child's educational or developmental services needs, and maintain the knowledge and skills that ensure adequate representation of the child's needs and interests with respect to education and developmental services. Another source of advocacy is the child's attorney. A primary responsibility of counsel appointed to represent a child must be to advocate for the protection, safety, and physical and emotional well-being of the child. Counsel must be charged in general with the representation of the child's interests. Although the attorney appointed for the child in the dependency proceeding is not required to assume the responsibilities of a social worker, the attorney must still investigate the interests of the child and report to the court the child's other interests beyond the scope of the juvenile proceeding that may need to be protected by an institution or other administrative or judicial proceeding. Attorneys or their agents are expected to meet regularly with their child client. This requirement exists regardless of the child's age or the child's ability to communicate verbally. Another source of advocacy for the child is a CAPTA-GAL, a Child Abuse Prevention and Treatment Act guardian ad litem. Each child in a dependency case gets appointed a CAPTA-GAL. Generally, the CAPTA-GAL must 1. Obtain first-hand a clear understanding of the situation and needs of the child, and 2. Make recommendations to the court concerning the best interest of the child. This might involve advising the court of information regarding an interest or right of the child to be protected or pursued in another judicial or administrative forum. This could include, but is not limited to, special education matters, a personal injury claim, or even a probate matter. If the CAPTA guardian ad litem learns of any such interest or right, he or she must notify the court immediately and seek instructions from the court as to any appropriate procedures to follow. Another source of advocacy for the child is the child's CASA, a court-appointed special advocate. A CASA is a person who volunteers to be a support person for the child during the dependency proceedings. Because of the person's relationship with the child, the court may receive information from the CASA, whether verbally or in a written report, about the best interest of the child. The CASA is to 1. Provide independent, factual information to the court, 2. Represent the best interests of the child involved and consider the best interests of the family, and 3. At the request of the judge, monitor cases to ensure that the court's orders have been fulfilled. Another source of advocacy for the child is the child themselves. The child is entitled to be present at every hearing. The child must be allowed to address the court and to participate in the hearing if he or she so chooses. And finally, you serve as a source of advocacy for a child. Any interested person may inform the court of a child's interest or right which needs protection or pursuit in another judicial or administrative forum. For more information, please see CILS's ICWA Advocate Guide for California Courts. It could be accessed at the hyperlink indicated below. We thank you for your time and attention. For more information, please see www.calindian.org.